Welcome to Employee Benefit Plans and Business Sense.
Hello and welcome back to Employee Benefit Plans and Business Sense with Lank and Kathleen Solis of KLB Benefits Law Group. And Kathleen help employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. With decades of combined experience in employee benefits law, they guide clients through compliance matters, corrections, IRS, and DOL audits. I'm Lisa Mosbey, your host, and today we are talking about COBRA requirements and the compliance issues employers need to understand when offering continuation coverage. Thank you both for joining me today to discuss COBRA compliance and coverage. This is a complicated subject for some folks. Kathleen, let's start with you. What is COBRA?
Well, despite how it sounds, it has nothing to do with snakes. It's an acronym for, the sexy sounding Consolidated Omnibus Budget Reconciliation Act of 1985. Now that's a mouthful. Basically, it's a law that allows a temporary extension of group health plan coverage in certain situations. And there is a lot of guidance, in form of detailed regulations, FAQs, but there are also many special rules and situations that affect how COBRA is administered. So bear that in mind as we talk about the subject, because I could run a whole half-day seminar on this topic.
So, Kathleen, what plans have to comply with COBRA?
Basically, any group health plan that's maintained by an employer with 20 or more employees. So, as you might expect, that includes medical, dental, and vision. But you might not know that it also affects flexible health spending accounts and many employee assistance programs, EAPs, telehealth programs, or any program or benefit that provides health services. There are exceptions for governmental plans and church plans.
And Kathleen, again, this is not COBRA insurance, where a lot of employees think that, oh, I have COBRA insurance. It's actually the right to have this insurance. Is that correct? Or do you want to clear that up for me so I make sure I'm saying it correctly?
COBRA is a right that's triggered by certain, events and a loss of coverage that allows them to actually continue their existing coverage.
Well said.
Even though they would lose it under normal circumstances.
That's what I wanted to hear. And then what events actually trigger a COBRA right?
So they are called qualifying events. And they include a termination of employment or a reduction in hours of employment, divorce or legal separation, the death of the employee, loss of a dependent status, or the employee becoming entitled to Medicare, which often will result in like the spouse and dependents losing coverage if the employee is no longer covered under the group health plan. And that's important to note that the event must trigger the loss of coverage. If it doesn't trigger loss of coverage, then it doesn't trigger the COBRA right. For example, if someone goes from full-time to part-time, they've had a reduction in hours of employment, but maybe their employer covers part-time employees the same as the full-time employees. So there's no loss of coverage. So that doesn't trigger a COBRA right. The other thing is that if a person can lose coverage for a different reason, if it's not one of these specified reasons that they lose coverage, then it doesn't trigger a COBRA right. For example, if an employee decides to drop their spouse or dependents during open enrollment, the spouse or dependent loses that coverage, but it's not because of one of these enumerated events, then it doesn't trigger a COBRA right. Although if an employee drops a spouse at open enrollment, but it's in anticipation of a divorce, then that can trigger a COBRA right. And it kind of depends on the facts and circumstances.
And then the death of an employee can also trigger a COBRA right. Is that correct?
Yes. I thought I mentioned that. Yeah, death of employee well, generally speaking, that triggers a loss of coverage for anyone else that the employee has on his or her plan, and they lose the coverage, then that would trigger a COBRA event.
So, Kathleen, we've covered the triggers of a COBRA, right? Who is eligible for COBRA?
Okay, good question. So it's basically the employee, the spouse, or dependents who were covered under that group health plan the day before the triggering event. So, for example, if the employee had never elected to have their spouse covered under the plan and the spouse is not covered, and then the employee loses employment, the spouse is not going to have a right to to elect COBRA, although that could change at open enrollment. But basically, they have to be covered under the plan the day before the event. And these people are called qualified beneficiaries, and they each have an independent right to elect COBRA. So, for example, if the employee and the spouse are covered by the group health plan the day before the employee loses coverage, but the employee doesn't want to elect COBRA, the spouse can still elect COBRA. So they each have that independent right. And there are special rules for that apply to domestic partners and their children.
And what does continuation coverage cost as a qualified beneficiary?
Okay, well, this is the painful part, I think, for qualified beneficiaries. The qualified beneficiary has to pay the full cost, the full premium. So whereas before, the employer usually subsidizes a certain portion of the premium, now that the qualified beneficiary is on COBRA, they have to pay both parts, the employee portion of the premium and the portion that used to be paid by the employer. And then on top of that, they can be charged an administrative fee up to 2%. And those payments are usually made on an after-tax basis by submitting a check or like an ACH bank payment for, on a monthly basis to pay for it.
And how long does it last, Kathleen? How long is continuation coverage?
Good question, because like I said at the beginning, it's a temporary extension. So for a qualifying event like termination of employment or reduction in hours of employment, the initial period, the maximum period is 18 months after the person elects the COBRA. For other qualifying events, spouses and dependents will get up to 36 months of this continued coverage. And then also if they're, another way to extend coverage is if it's an 18-month maximum period of coverage, but during that time, one of the qualified beneficiaries is determined to be disabled by the Social Security Administration, then there's like a 11-month extension on top of the 18-month period for all qualified beneficiaries. Also, if the maximum period, say, is 18 months, again, like a termination of employment, but a second qualifying event happens during the 18 months, like, for example, a divorce or the death of the former employee, then that period of 18 months could be extended to 36 months. And these are the maximum periods, but they can be cut short. For example, if a COBRA payment for the premium is not made on time or within a grace period, and if the employer stops offering any group health plan, and that you have to look at the whole related employer group, but if there is no group health plans offered by that employer group, then the maximum period is ended. And also, if the qualified beneficiary gets other coverage, maybe, or becomes entitled to Medicare, then that can shorten that maximum period.
And what does the employer have to do to help someone get set up with COBRA?
Well, there are a lot. As I said, there are a lot of rules that apply to COBRA. And so employers need to have written COBRA procedures that they follow, not just that are on paper, but they actually have to follow them. And in order to administer COBRA, they can hire a COBRA, like a third-party COBRA administrator that they've checked out and vetted, made sure they're good at what they do. Or if they don't do that, then they have to ensure that their in-house administration is established. And in either case, the employer has to still, provide oversight. They have to provide a bunch of notices. There's an initial notice which alerts all covered persons in the group health plan that they have COBRA rights or they may have COBRA rights. And that has to be given to everyone when they become covered by the plan, which seems simple. Like, someone elects group health coverage, then they get the notice. But it also can happen like maybe they don't elect to have their spouse covered at first, but then later down the road, they elect to add the spouse due to an open enrollment period or a special HIPAA enrollment period. Then that spouse needs to get the notice. You can't forget, you provided it to the employee starting out, but you've got to provide a second one to the spouse later if they are later added. There's a notice, and let me just specify, there's certain rules about notices where that apply to the employer and then to the plan administrator. And sometimes it's mostly the same person. The employer is the plan administrator, but there are situations where they're separate. So I'm just going to sort of simplify it and say and treat them as the same. And so the employer has to provide qualifying beneficiaries the qualifying event notice, which, if they're eligible for COBRA, then they get this qualifying event notice or a notice of unavailability if they're determined to not be eligible for COBRA, basically within 44 days of the qualifying event. If the coverage is going to be terminated early because of one of those situations I mentioned, they have to give a notice of that. If a payment that's made by the qualified beneficiary, then they have to let them know if their payment has an insignificant shortfall, and sort of letting them know that, hey, you paid slightly too little, you need to make it up. Let's see, there's also, if a plan, a group health coverage plan has a right for the qualified beneficiary to elect to convert that policy at the end of their maximum COBRA period to an individual policy, then they have to provide them a notice. And then basically anything else that they would, do for any participant in their group health plan, active employees, for example, providing summary plan descriptions, summary of material modifications, and that open enrollment participation, that all has to, the qualified beneficiaries have to be treated the same as other participants in those plans. They also have to, if they get an inquiry during this sort of period where the person has a right to elect COBRA but hasn't elected it yet, or they've elected it but they haven't made their first premium payment yet, and the coverage will be retroactive, and they get an inquiry from a healthcare provider saying, do they have coverage? They have to, they can't just say, no, they are not currently covered under the plan, which is literally true, but they have to, let them know that the coverage, they may be covered retroactively under COBRA. They need to make sure that, the participants, the qualified beneficiaries' elections and payments get to the insurer if it's a fully insured plan. And they have to have, and this can be part of their written COBRA procedures, but they have to have reasonable notice procedures for those notices that the qualified beneficiary is required to give to the employer or plan administrator. It's a lot.
It is a lot. And I want to transition over to, what does the employee or qualified beneficiary have to do?
Well, they have to notify the plan administrator of a qualifying event that they would be the one that would know of, and the employer wouldn't know, the plan administrator wouldn't know. For example, a divorce or a legal separation. They need to notify them within 60 days of the event. It also, if the dependent loses dependent status, they age out, then they've got to notify the plan administrator again within 60 days of that event. They also, if they're offered COBRA and they want to elect it, they have to, elect it basically within 60 days of that notice of the qualifying event. And if they don't, they're basically forfeiting their whole COBRA right. So they need to do what they need to do to lock that in. They need to make their first premium payment within 45 days of electing COBRA, and they need to make all payments in the future on time and by the method specified by the employer. So that's very important. They need to notify the employer if there's a second qualifying event that happens during the 18-month maximum period. As I mentioned before, like the death of an employee or the dependent ceasing to be a dependent during that 18-month period. They need to notify the plan administrator that when they get other coverage, including an entitlement to Medicare, and also for that disability extension I mentioned, they need to notify the plan administrator if the qualifying beneficiary becomes determined to be disabled during the 18-month period. And then once that happens, if the qualifying beneficiary ceases to be determined to be disabled, then they have to also notify the plan administrator of that.
And Kathleen, how do state laws regarding continuation coverage impact COBRA?
Well, there are a lot of state laws that are what that is called a mini COBRA law, and basically what they do is they fill in gaps. They can add to COBRA, fill in the gaps, and a lot of times they apply them to the laws to insurers, not employers, and that's how they kind of get around preemption. And for example, in California, we have what is called a CalCOBRA, and which applies to employers with 2 to 19 employees. So the smaller employers that wouldn't be normally subject to federal COBRA. And the insurers in California have to offer COBRA-like coverage to the qualified beneficiaries.
And then my last question for this episode is, are there penalties? And what are the penalties for failure in compliance?
Well, there are many different penalties that could be assessed. There's an excise tax, which is $100 per day, $200 if there's more than one qualified beneficiary affected for the same qualifying event. And for each day's failure, basically they can be assessed this excise tax for the full, what's called the non-compliance period. There are also statutory penalties, and these would be generally assessed by a court. And for a single employer, that limit is there's a limit of $500,000, or if less, 10% of the amount the employer paid during the preceding taxable year for group health plans. Also, plan administrators that are subject to COBRA can be assessed penalties of up to $110 per day if they fail to provide that initial COBRA notice that we talked about, or the election notice on a timely basis. And then, the biggie also is lawsuits. Qualified beneficiaries can, sue in federal court, and they can get large damage awards. For example, if they were medical expenses that should have been covered under COBRA but weren't, then you've got the employer having to pay out of pocket for that. And keep in mind that all of these things we talked about today are minimum requirements. So an employer can be more generous as long as, if it's a fully insured plan, they have to make sure their insurer is on board with whatever they're offering that's beyond the sort of the COBRA minimum requirements. And sometimes insurers are agreeable, but you don't want to, employer does not want to make promises and then have to self-insure. And then, I think the sort of the thing to take away is if despite the great amount of guidance there is on COBRA, it can still be tricky. And so, it's best to get legal counsel if anything out of the ordinary happens.
I want to thank you for all the details. This is complicated, and so many of us go through it as employees that it's nice to have someone available to shine the light on it for us. So thank you so much for your time today.
Oh, you're welcome, Lisa.
Folks, thank you for listening to Employee Benefit Plans and Business Sense. If your organization has questions about COBRA compliance or continuation coverage requirements, visit klblawgroup.com to connect with Dal and Kathleen. Be sure to like, subscribe to the show, and leave us a review if you found this episode helpful. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.